So after the plaintiff puts her or his case together, the defendant puts her or his or its case together.
It's?
Well, it's an employer, it's a corporation typically. But the cases are put together, brought to a workers' comp judge or magistrate, as you said. And what happens at trial?
When trial finally happens, well, let's back up. What would be the number you and I could agree on? You would think, as an injured worker, hey, I finally got my day in court, we're going to have a trial. But of all the cases that actually file that application to get a trial, 75, 85% settle? It's probably some high number, correct?
It is a very high number, yes.
That's because, it's not because you or your attorney is caving in. It's because the employer often will dispute a case and not pay you something that you deserve, but then once they've made you go through the hoops of taking the testimony and submitting the evidence and having their attorney hopefully give them an honest analysis of the case. Let's say the attorney says, hey, the way these testimonies and the proofs came out, I think, this case is worth $150,000, sorry to tell you. Well, then the employer will have to bite the bullet a lot of times, and they will offer some money. I don't want to get your hopes up. Often it's not $150,000, but often on the courthouse steps, as they say, a deal can be struck. Often on the day of trial, because that usually is the day that the employer finally is willing to disclose most, if not all, of what money they have. But if you do go to trial, that was your real question.
Yes.
You want me to go on?
Sure, yes.
You often, well, this is changing. I was going to say you often have to wait half the day before your trial starts, but a lot of magistrates, if you finally have achieved the #1 seniority, first position on the trial docket, they will tell you show up at 8:30 or 9 and we'll start then. But you may have a wait. When your trial finally starts, it's your burden originally to prove to the magistrate that you have this compensable injury. And remember, it's not enough that you've lived with this pain for months or years. I mean, you in your heart know that you deserve this money, but it all has to depend on how the money actually how the records rather go into evidence. So trial is very important. Your attorney will have planned questions. He or she will start out often by calling you first, and it starts out with they usually ask some basic biography questions. How old are you? Where do you live? What's your date of birth? Maybe get a little more background about if you're married and whether you have children, where you've lived. Interests, even perhaps hobbies if they're pertinent, because they can become pertinent all the more if you can't do them anymore because of your injury. But sooner or later, your attorney, the plaintiff's attorney, will get into your education and training, because remember, that's going to become pertinent to the judge to decide what you can and cannot do. And I don't know if I ever finished my earlier point about that. It's not enough for Frank to show that he can't be tool and die and newspaper delivery and cook anymore. The inquiry actually goes beyond that. If Frank cannot do the jobs he actually has done in the past, is there any other work, even if Frank never did it, that he would be qualified for as a result of his skills that he can now do? And perhaps one example would be as a newspaper delivery, he interacted with people a lot. He talked to people as they go get their newspaper. And the defendant's vocational expert might say, well, that translates into Frank being good with people, good customer skills. I think he's qualified to be a teller in a bank. Well, Frank's never done that in his life, but arguably, that's something that you'd have to address about whether Frank can do that or not. So, moving back to the trial, that's why your attorney gets your training and background into the record. And then a lot of the focus is on your day of injury or your days of injury. It can be multiple days. And the attorney will want you to go into quite a bit of detail about what happened then, what pain you felt immediately, what you reported when. Remember, we talked about trying to tell the employer right away what you feel. And then it sort of is just a historical summary from there on out. What doctors have you seen? Have you looked for work? What do you not do now that you used to do? And usually the questioning ends with, well, how do you feel today? And then after that, the other attorney gets to ask you questions, and that can be a bit more combative. And then after you're done, any other witnesses, often there's an employer witness, often it's a supervisor or a human resources person that'll talk about their experience with your case. Often if there's a surveillance investigator, they testify sooner or later. But many trials can be wrapped up in one day.
You indicate one of the questions that the injured worker's lawyer might ask is, of the injured worker, are you looking for work? Why is that now important?
It goes to that second big factor about what you're able to do even if you are injured. And the one thing in the law that's in the injured worker's favor is that the law says that these vocational experts, well, the law allows vocational experts to say what jobs they think you can do, but you as an injured worker can rebut that fairly well if you can honestly say, look, I looked into those jobs. I looked for that work. The law talks about how a good faith effort to look for work can possibly defeat defense vocational experts' recitation what jobs they think you can do. You can say, I looked for them. I'm still unemployed.
So after the various evidence is taken from the injured worker and from any witnesses from the employer, from any surveillance people, any witness that the employee might wish to call to try to rebut, say the surveillance representative, the judge concludes, and you say often it's within a day. Then when the judge does what?
Well, then, with most judges, and this is not really a reflection on the judge, but on the system, because they have so many cases, with most judges, then you wait again. And a quick turnaround, you will, sooner or later, you will get something in the mail that says how the judge ruled on your case. And your attorney will get one, and you can call each other and talk about where you go from there if it's something less than a total victory. Or often, even if it is a total victory, you have to talk about what to do, because the employer may still have a trick or two up their sleeve on what to do at that point. But you don't learn the day of the trial how the judge is going to rule. I hear that's how it was done in the old days, but for many, many years, you have to wait for the judge to issue a written opinion. Once that opinion is received by all the parties, you know where you stand.
And as you indicated, once that opinion is received by the parties, you know where you stand for that moment, but then there's more activity in relation to appeals.
If you win, if the injured employee wins, and there's different kinds of wins. There's something called a closed period where the judge says, yes, I think you were injured, but now I think as of such and such a date, you got better, so you only get benefits from point A to point B. The better kind of win is what's called an open award, where the judge says, for the ongoing into the future until anything changes, Frank gets his benefits. If you get any kind of win, you'll be due some money that probably will be paid you, but the employer can string that out. And for that matter, either party that's aggrieved, if you're the injured worker and you're loose, either party that's not content with how the magistrate ruled can ask for reviews at higher levels. And with those reviews, there's rules in place that talk about how the injured worker is to be paid benefits if they've won with the magistrate, but they only are paid 70% of the benefits.